Miranda's there for the admissibility of the statement. It has really not much bearing on the securing of evidence. So when they Mirandize, it's really for the protection of any confession or admission that comes subsequent to the Miranda warnings. So really, when we talk about evidence, it's Fourth Amendment, and statements in Miranda's Fifth Amendment. So when we talk about the securing of evidence, it's really the reasonableness, because the Fourth Amendment prohibits unreasonable searches and seizures.
Yeah, exactly right. David, thank you for that. And yeah, so apparently one of the other things, I know we're talking a lot about the phone, but yes, her statements, they want to keep them out, everything that she said. And generally we think of, I'm going back to law school, David, I think of my professor, I can still hear him saying custody plus interrogation equals Miranda. And so here, do you think this could get tricky with whatever came out of her mouth? Because as Claudia noted, she's not detained, but maybe she didn't feel free to go. What do you think?
Exactly. Okay, so custody is defined as a reasonable person would feel they're not free to leave. Interrogation is a statement that would elicit an incriminating response. So they don't have to be in cuffs. They don't actually have to be detained, like told they're detained. It's what does a reasonable person feel in that same situation? And certainly I think most people would have felt that they're not free to leave when there's police in the house, they're securing a search warrant, there's police around. So that gets you to custody, even though there's not handcuffs. And then the next question is, what was asked of her? And is it reasonably likely to elicit an incriminating response? So that's the two-step analysis for that particular issue.
I love it. David, Bruno, thank you. Great law school lesson this morning for all of our courties. David and Claudia, thank you both.